Hi, friends. Welcome again to another episode of Beyond the Clouds, Edge to Edge Transformation. Here is Eric Lamison. Eric, tell us about your journey through technology and outside of technology.
Pleased to be here to talk about technology and law, which is something I feel passionately about. I'm an intellectual property lawyer. I graduated from Michigan Law School in 1995. I moved to California to join a law firm, Kirkland Ellis, or K&E, one of the best litigation firms in the world, and started as a commercial litigator doing commercial disputes straight out of law school, working the hours that you would expect as lawyers do. About 2 or 3 years into the job, I was sitting in the lunchroom and said, "Hey, do you want to work on a patent case?" I'm like, "What's that?" I got involved in patent litigation. My first case was for Siemens Medical Systems involving MRI technology. I didn't really have the experience at the time, but I thought patent law was very interesting. In the 90s, there were fewer people that were focused. IP, patent law was known in tight circles. So I got involved in it in the 90s, late 90s, and I loved it. So I learned it, and I decided to focus on that exclusively, patent litigation. I became a registered patent lawyer with the U.S. Patent and Trademark Office. And from there, I had a 20-year career with Kirkland Ellis, where I was in court or in the International Trade Commission in Washington, D.C., trying patent cases, either defending companies against infringement allegations or pursuing infringers of patents. From there, I went in-house to Cisco Systems, who was my client for many years. I defended Cisco in courtrooms across the country successfully. I went in as a vice president of IP litigation, where I was responsible for worldwide IP litigation for Cisco for a little over 3 years. And now I'm a strategic consultant with my own firm. So that's my background. I am a litigator, trial lawyer, intellectual property specialist, dating back to the 90s when this was kind of the nerds in the corner. Not anymore.
Yeah, patent law has grown quite a bit. How do you keep up with all these technologies? You started with the Siemens MRI cases. That's medtech, medical devices. You worked on all kinds of things, especially at Cisco, routers, switches, telecom devices, at a time when there was so much going on between Cisco and Huawei and others. How do you catch up with all these technologies? It's moving at breakneck speed.
So that is one of the joys of the profession. There were two things I loved about being a patent trial lawyer and being a patent litigator, and this dates back to the 1990s. One was understanding the patent law and explaining it to judges and juries who didn't have the background that we had. And all patent cases are in federal court. That's how it works because of the exclusive jurisdiction. And all federal cases go up to the Court of Appeals for the Federal Circuit. So sitting federal judges across the country have jurisdiction over patent cases. They have very busy dockets. They have a lot of criminal cases and other cases. And if they don't have the background in patent law, which many of them at the time did not, and many still do not, these cases can really eat up their time. So one thing I really enjoyed was explaining patent law and what it means and how it works to judges and to juries. The second thing was technology. And the thing about it was it evolves. So I worked on all kinds of different things. For me, what I feel like was part of my differentiator was my ability to understand pretty much almost every different type of technology, really comprehend it, to get to the point where I could explain it to somebody else who didn't know anything about it in a way they would understand. That's very important. And also the ability for me to understand it well enough to cross-examine the technical expert who's a lot smarter than me and more technical was important. So I really had to understand it. And I got to work on a lot of great things. My first case was the MRI equipment. Siemens made this system where you could do open MRI, where you can get surgery inside the magnetic bore. Of course, it's a huge magnet. A gentleman had patents that he thought were infringed that related to filtering and shielding so that displays like LCDs and plasma displays or even goggles for watching a movie won't interfere with the image. When you're getting the MRI, because of all that magnetic field, will disrupt like a television. Now, the thing is, unfortunately for the gentleman, magnetic displays like LCDs and plasma are magnetically inert by nature. It just means they're not going to be affected by the magnetic field. So the patents we contended were invalid and that we didn't use them. That was my first case. Then I worked in the gaming industry, gambling machines, slot machines, card shufflers, a lot of IP in that area, which was a lot of fun. We'd have cases in Las Vegas courts, which I personally, as a young person, enjoyed. Cisco, networking, routing, switching, which I love.
Now, dealing with the federal courts in the United States is one matter, but when you're dealing with international patents and say between Cisco, I believe, had to deal with courts in other parts of the world as well, right? So how easy or difficult is it? What jurisdiction does it come under?
So patent cases, there's a sort of a plethora of ways that this can work. In the sophisticated cases, and I worked on a lot of the big disputes, the billion-dollar type disputes where people were suing for a lot of money. There's really two types of patent cases that I would refer to. One would be competitor litigation. That's if two companies that are really competing in a marketplace for market share battle over market share through patents, which are legal monopolies. That's a word nobody likes to use, but a patent is an exclusive right to use your invention for a period of time, which is currently 20 years from the date you file your application. So it is a legal exclusive. Number two, there can be what are called, people used to call them trolls, like a troll under the bridge collecting money. Then they called them non-practicing entities. Then they called them patent assertion entities. Then they called them licensing organizations. The bottom line is there's folks out there that have companies that are focused on licensing. And what they might do is buy patents, for example, try to monetize them by collecting royalties. So you have these two things, competitor and NPE cases. And now how are they going to go to the courts, and what are some of the interesting parts about that? Typically, there are courts in the US that have a lot of patent cases. Delaware has a lot because companies are incorporated there. So jurisdiction is important. And because patents typically involve companies that sell and make products and distribute them around the world, they're typically people that work in different areas. Used to be able to go anywhere. It's getting harder because it depends what your real presence is in areas or cases will be transferred. Delaware gets a lot. Texas gets a lot, some of the California courts. Generally, people don't sue your customer or your client in their home jurisdiction. They usually sue you somewhere else. Real or not, people just perceive that. You may not get sued down the street. You might get sued somewhere else. So there's the district courts, and they typically award damages and possibly injunctions. Then you go to the International Trade Commission, the United States. They have jurisdiction over imports, and patent infringement can be an act of unlawful importation. And if you win a case at the International Trade Commission in the United States, you will block the infringing products from being imported in the United States. That's a big stick if you think about it. Like if someone can no longer bring their switch or router into the United States, and it's completely banned, and many things are not made here, as we know, that's a big issue. Overseas, Europe, for example, there are patent courts throughout Europe, and there's been some changes in the structures over there. But for example, many cases are brought in Germany, and Germany tends to give injunction, which would stop you from selling products. So you have this sort of tiering system. You have the district courts, the International Trade Commission overseas. And in a sophisticated real patent war, like the big ones, the big patent wars, if you think back, I think Samsung and Apple, for example, or whatever, those cases, they may have cases all over the world.
I had the unique privilege of translating legalese to geek speak when I was at Sun Microsystems and later at other chip and system companies. And geek speak to legalese because technologies and lawyers don't always see eye to eye. Technologies feel bound when they're told to do certain things, protect certain IP, or not protect certain IP, and they don't always understand. Did you have that privilege also, being on the other side, helping engineers and engineering managers or scientists understand what can and cannot be patented and should not be patented?
I did some of that. Most of my career was in the disputes area where it was either in court or going to court. So most of my time was dealing with it after something had occurred. That being said, I have had experience giving folks advice about the trade-offs and things like that. For example, trade secrets. If you have a trade secret, something that's protected in your company, when you go apply for a patent, your patent is a public document. Your specification that describes your invention is made public. You have claims which define what you exclusively own. It's like the deed for the property on your house, the metes and bounds of what you own. If in your property, if you have a home or a condominium, either a measurement of the square feet of your house or your apartment or your condo or a deed or something. And in a patent, there's a technical document which describes what the inventors have invented, the claims at the end that say, this is what we own. There's a lot of dialogue that can happen with the engineers, which relate to topics including, number one, and this is a company decision, really. If it's a trade secret, you have to ask yourself, do you want to put it in a patent or not? If it's a trade secret and nobody knows how to do it, then they can't really copy it. So why disclose it in the patent? Having a patent and having a claim doesn't mean you've stopped anybody. You actually have to go out and enforce it. There's a lot involved there. That's one big question. Is it the thing that you can see from the product, you can see from the marketing literature, or you could easily reverse engineer? Well, if the answer to that question is yes, if everybody's going to know what your technology is by seeing your product, reading your white papers, reading your marketing literature, even an easy disassembly, well, then you might want to patent your invention because it's not a trade secret. Trade secret might be the formula for Coke, which probably none of us know. Second question is prior art. That's a big word, prior art. And in our field, it means, was it done before? Was it done before you filed for your patent? There used to be a bunch of rules about when was it invented. Now we're mostly focused on filing dates. The world is mostly focused on filing dates overseas and in the US. Did somebody do it before you're filing for your patent? Did somebody do it publicly or in a patent that was already applied for? Was it done? Was it on sale? So you have to say, well, if it was done before, the patent's going to be worthless. It has to be novel. So I have discussions with engineers about that, either in the context of, do you want to get a patent? Do you want to put it in the public space in exchange for getting claims? That's the trade secret question. Is it really novel? Is anybody going to do it? That's the next question. Do you think someone's going to do it once they see you're doing it? And if so, yeah, you want to patent it. Patents aren't cheap to get. They're not horribly expensive, but you have to hire lawyers. You have to go through the process. You have to ask, well, is it worth the investment to get this claim? If the answer is yes, then go for it. Finally, if you're a startup and you don't have any patents, you're kind of exposed. If a competitor says, we think you are using our intellectual property, what's your response? Do you have a response? Building your own patent portfolio is a defensive mechanism inherently as well. Back when Cisco was originally sort of emerging and becoming a large company, the gentleman who was at the time the chief patent counsel, Robert Barr. I really enjoyed being around. I enjoyed working with him professionally. He was a real scholar in the field and an innovator. He realized Cisco better build a patent portfolio or people are going to keep knocking on the door and there's no response. Those are some of the decisions you have to make about getting a patent. It can depend what's the size of your company, what are your goals, why to do it. But it's a really important part of any technology company.
We are in unprecedented technology times. We've got AI, machine learning, Gen AI, even AR, VR stuff, even on the platforms on medical devices, handheld devices, even software as a medical device. The question is, when things change so fast, what are the rights of people? Because there may not be an IP at the time of filing, but later something changes. For example, what about OpenAI and ChatGPT and a lot of the stuff that's going on? Laws that can go and stop people from taking other people's IP?
The area of AI is very disruptive in so many respects, including intellectual property. And there's a lot of ongoing, developing questions in this space that I don't think have yet been definitively answered. Even if they've been answered by one jurisdiction or one body, who's going to be the ultimate arbiter? And will some of this eventually make its way up, for example, to the Supreme Court of the United States of America, who ultimately, if there's different courts coming down with different decisions, can ultimately decide what's the right law, for example. And there's also things happening, regulations in Congress. But what are some of the issues with AI? It's extremely disruptive. Number one, from a patent perspective, you need to have an inventor. The person that invents the thing that goes into the patent. It can be one or more, it can be multiple inventors, but those are human beings. Those are people. That's the name on a patent. The patent has a title. It has the inventors. It has a number. Here's my patent. You get an award. A lot of people put them on the wall in a plaque. Human being, people, engineers. Those are the inventors. So what happens? You're working diligently using an AI tool at your company, whether it's small or big, and you create an invention using AI. Can you get a patent? The answer seems to be right now, probably not. AI, being a named inventor, has not really been embraced in this country as being permissible. There's court cases in Europe. There's cases here. The answer seems to be leaning no. But then there's gradations. What if you just use the tool and it helps you to make the invention? You can start to imagine, is there a bright line? Like if the computer just push a button and it pops out an invention, probably no, there's no inventor, so that can't be patented. So you created something. It might be novel and new, but AI did it. Not you. No patent there. But what if you used the tool along the way? And to what extent did the tool participate versus you? That's where I think you're going to see a lot of interesting questions on the patent side. The other interesting question on the patent side is how much detail will they require in patents that try to patent around AI? The example I was just talking about was the question of if AI creates what might be intellectual property. I'm talking about patents right now. There's other areas I'll hit, like copyright, things like that, but let's stay on patents. So the one thing I just talked about is what if AI is purportedly the creator? The next thing I'm going to talk about in patents is what if you're trying to patent an AI generated technology, like the AI itself, not the AI creating something, but you've created a new way of using artificial intelligence for something in your technology. You've used machine learning as part of your invention. So now you're claiming an invention that makes use of AI. You can patent that. That's different. Well, what's inventive other than saying you're using AI? You got to invent something. Otherwise, you're just taking a computer and doing something. So there has to be some novelty there in how you're using it. And there probably needs to be some description about what you've done that's different and new. So it'll be interesting to see what comes out of the patent office, and it will be interesting to see what happens in the courts when people go to enforce these in the next decade, because that's going to be what you're going to see. You're going to see a lot of patents in AI being asserted. That's a future in patent litigation. You're going to see court cases between companies, whether it's competitors saying, you're using my invention, I patented this use of AI as part of this great process. This is my invention. You got to stop. You can't do it. Or you're going to see people that are buying these patents and going into licensing campaigns and saying, you need to pay us. I think you're going to see a lot of patents being asserted for the next decade where the claims of the inventions make use of AI in some way. So that's the patent side of the house. You're going to see a lot of the question of, is AI the real inventor? Who's the real inventor? I always try to think of new ideas or new things to argue or new defenses. So you can imagine there's going to be a scenario where a company comes into a court somewhere, maybe Texas or Delaware or California, or says, I've got 6 patents that cover what you're doing at your company using artificial intelligence and whatever you're doing. You're going to get discovery. In fact, they may not even be accusing artificial intelligence, but they have a patent. And you're going to go as a lawyer, you're going to say, I want to see the invention records. I want to know how you came up with the invention. Where were you sitting in your office? What computer were you using? What model and make was that? Do you have a notebook that shows how you came up with the invention? How did this happen? It may shock you. People are not always 100% candid when it comes to money. Can you imagine the scenario where somebody puts their name on the patent, but omits the piece of information that it was really ChatGPT that came up with the invention? They just claim their invention. So if you think about it, if AI is not allowed to be an inventor, but somebody comes up with an invention using AI, there might be instances where people just put their name on the patent. If I'm defending a case, I would want to know, how'd you invent it? Because I would be inherently skeptical.
Now, Archimedes looks much easier. Shouting Eureka and jumping out of his bathtub sounds much more real. You have worked in this area for quite some time. What we keep hearing is that the legal profession is going to change because a lot of the research can now be done using, say, generative AI, and you can dig out some records in the past. Do you think it's going to change the way law is being at least researched and legal cases are fought using all these AI-based tools?
Yes. I don't know that I'm happy about it because there's the issue of quality. The reality is, yes, it's going to be very significantly impactful in the practice of law. Not so much for me because I'm in my consulting role and I've moved on from big firm litigation. I'm at the stage of my career where I'm providing ideas and creativity and strategic wisdom that can be applied and scaled up. See, I have the experience, I have the knowledge that AI can't replace. I have a lot of expertise. I was at Kirkland Ellis for 20 years. I had the hardest cases in the world, and Cisco had tough cases. So I'm a lot of firepower sitting on the sidelines for a reasonable fee. However, if I think back to the beginning of my career in 1995 when I came out of law school and the things that I was doing, like reviewing documents to try to find key facts, researching legal issues to write legal briefs, those various tasks, I'm sure there's a belief that you can use AI and algorithms and machine learning to go through the documents, scan the documents, OCR the text, look for pattern recognitions, and create an output that says, well, here's the 12 interesting ones. Eliminate thousands of hours of work. And also legal briefs, you can push a button and say, write me a brief. And a partner who has more experience can edit the brief. The thing is, there's a trade-off in the quality if you start taking the innovation of the human mind out of these questions. I had a case where I was defending cable modem equipment manufacturers and the cable companies. One of these patent holding companies, private equity, wanted to make money off patents called Rembrandt. They were suing all the cable companies in the US to try to say that every cable modem that is in the United States infringed a patent. So there were patent cases all over. They wanted a piece of royalty on the service revenue of your cable subscription monthly from everybody in the country from the cable companies. So that's a big case. They had 8 patents that they had purchased from a company called AT&T Paradigm, which went out of business out of Largo, Florida. We came in to take over the case, Kirkland Ellis, myself and my team, and we had to step into this massive patent litigation, at this time consolidated in Delaware, and come up with defenses about why we didn't infringe or whether the patents were invalid. It was a difficult case. These were AT&T Paradigm patents. They had a sophisticated patent program, people that were really focused on patents. So how are we going to defend the case? Why weren't we using the patents? What was our defense? So I had to go into the documents, and there were a lot of documents that have been destroyed, which is a story for another day, but there were some documents that were left in a warehouse. So how did I go through those documents? Did I use a machine? I didn't use a machine. I had my team go through and index all those boxes and give me a description of what was generally in them. And I went through those descriptions of thousands and thousands of boxes, and I sat in a conference room and I picked the ones that I wanted that I thought might have something interesting, because I know the patent law really well. And I know what people do, and I know the psychology of people. I know people sometimes lie. I was thinking, what are we going to do to defend this? So I had boxes sent to me, and I sat up there for months, and I just went page by page. I found a lot of stuff that AI never would have found. I found the name of an intern who had a performance review. And in his performance review, it discussed how he went on a roadshow and showed the products. And the thing is, if you show the products before you patent them, you can't get the patent. That's the old rule. The rules have changed, but you got about a year from when you put it in the public to go patent it. And I saw in one random file folder of a performance review of an intern from like 25 years ago at AT&T. And in the performance review, they were saying we had a birthday cake. He went to the hotel. We went on the road. And I said, that's an on sale bar. I found this guy and called him and asked him. And turns out he had documents left from his time at the company that his manager had approved him taking and keeping. So he was legally allowed to have them from all of that roadshow. And we had evidence to invalidate the patent. There's no way artificial intelligence would have figured that out. And I'm not doing like, hey, I'm great. I was proud of myself, but AI wouldn't find that. So what's the trade-off? If you're going to use a machine to go into the documents and look for patterns, you're not going to find the needle in the haystack. You're going to get more of the quick and easy answer. The case is worth $1 billion. Do you want the quick and easy answer or you want the needle? So for me, I know this is coming, but I don't think it's good because it will turn off that training process of the person. The people that come up won't have the ability to do that because no one's going to want to pay for it anymore. As a result, the skill's not going to be there. Ultimately, you won't know how to do what I did because machines do it. Ultimately, people won't know how to find the needle in the haystack the same way. So from my perspective, I think it's a loss in quality. And that ended up being a defense where there really was a difficult patent with not much to say. And that was 100% a defense, and the patent fell apart. I think the same thing with legal writing. If the legal writing's not going to be as good, the up and coming lawyers won't be trained the same way. And then when you think about where I'm sitting now, I have all 25 years of experience. So I can read something and know what's the deficiency of what AI did. But if I came up in the era of AI, how am I going to look at AI critically and say this work product isn't very good? I think it's a great thing. I'm concerned about excessive automation replacing people.
Yeah, but like in the good old days, hopefully people will use similar products to train people as well. It's a tricky one, and I don't know if there's a simple answer to it. How do you train lawyers to find that needle in the haystack? Hopefully, there will be some smarter mechanisms for guiding them when they're not actually doing the hard work.
I'm all for embracing technology. When we learned how to OCR, optical character recognition for documents, once they started to scan documents and you could term search them, that made things faster. Like there were benefits there versus looking at individual pages. There's trade-offs. The training part is a concern. I did hear one really good interview, Mr. Khan, the founder of Khan Academies. One of the things that they were talking about, students not going to learn math correctly because they're just going to type in and get the answer. And he was using it as a tutor, like a training tool. It was teaching you math using artificial intelligence, forcing you to answer the questions. If you didn't get the answer, it was forcing you to know why you didn't get the answer. To me, that was an example of, yeah, we're going to use AI correctly as a teaching tool. So maybe in the legal profession, there'll be ways to do that, to train lawyers so that we don't lose the skill.
I know we are hitting that in every domain we consider easily automatable skill, replacing humans. Therefore, the leapfrogging may or may not happen. Speaking of which, you were at Cisco and you must have had lots of firepower, lots of attorneys to work with. It's a different ballgame when you're on your own. Which one do you like, and what are the trade-offs when you work on your own versus you're in a big team?
For me, I'm very fortunate that in my strategic consulting role, I'm still working with teams. I was at Kirkland Ellis for 20 years, and I had case teams there. We worked across the world. When I first started, I had a Toshiba satellite laptop. We believed in remote work in terms of teams, like working together across the country and across the world. We're talking 1995. I was able to work on teams as a litigator. We had case teams. We had lawyers in all different time zones to keep it going. I really enjoyed that. I felt like I was good at depositions. I was pretty good in court too, I think. Also, I was the driver of a lot of the ideas for these cases. If you think about, I only have two hands, but if I have a big team, I can like scale my thinking and ideas across the troops that can go out and do the heavy lifting, the litigation work. Being a coach and a player at the same time is difficult. I like being the coach probably more than being the player. When I went to Cisco, I had big teams there. But now, even though I'm on my own, I'm still in charge of teams. The people are bringing me in as a consultant. I'm still providing instruction, driving collaboratively ideas to tough problems involving tough IP issues, tough litigations. And I can bring that high-level experience that you would pay millions of dollars for if you hired a big law firm. I can provide that expertise to your case and help your teams get to the right answer by being a collaborator and a consultant. So I'm not working just here in my office on my own at all. I'm working with teams of people across large companies and law firms. So I'm really in the same position, except it's Lamison PC, my firm. I'm doing similar work. I'm just not the guy in court. It's like the surgeon. I'm not the guy in there doing the slicing or whatever. I'm in the back helping give ideas to the superstars that are doing what I used to do.
So you almost become a quarterback in the legal IP battles.
Funny you say that, because I had a client in the gaming industry that called me the running back because I had to rush it up the middle. But I was like, well, I'm the running back, but I'm also the quarterback. So I'm a running quarterback. I love what I do. I feel like I have a lot of firepower sitting on the sidelines, and I'm hoping to grow my practice to work with more companies that see value in what I can do. When Cisco called and said, hey, we got a problem, my phone would ring. I'm the same person, but I'm here on my own, and I don't compete with the big law firms. That's not realistic, but I'm here to help them. I can help your teams on big cases. I can help you before there's a big fight. I can explain what's going to happen. I can give good ideas. I can come up with good arguments, like the one that I thought about, like, who's the real inventor? Because people may file for patents, even though they really use ChatGPT, but they don't want to admit it. How do you figure that out? That's the stuff I can bring, is new creative ideas.
You've been doing these things since 95. Surely it's changed your life. In what ways are you a different person than when you started in 95?
It's been a huge journey when I look back at it. I always worked extremely hard. And for me, I had a passion for what I was doing, but I've gotten smarter along the way. I now have a lot more wisdom from having been through the process, but I did the heavy lifting along the way. Quite frankly, it's hard. If you think about the life of a professional athlete, like a hockey goalie, how many years can you stand there in the goal playing professional hockey and having everybody shooting all those pucks? At the time I was doing it, I appreciated that there would be a time when I was going to say, I need to level up. I don't think I can stand in the goal forever. I was always a startup guy. I went to Kirkland Ellis, Los Angeles. It was a 20 lawyer office. I chose that of the larger home office because I wanted to distinguish myself, and it worked. A lot of opportunities. Then I moved to San Francisco to open our office in 2003. 5 partners relocated to the Bay Area. We opened in San Francisco in 2003, and we quickly grew it to over 150 lawyers. We were all leaders in our field. I did that for 10 years. Then I went to Cisco to reinvigorate the IP litigation team, where they needed someone to come in because they'd had some departures and they wanted to keep the team together. And now I'm on my own. So I always feel like I have a startup entrepreneurial mindset. I've come to realize that I've taken some risks over the years and I've been rewarded. I guess I look at the whole thing. I feel like the difficult choices along the way to take these risks paid off. At the end of the day, it's the right progression, because what I'm doing now, I don't think I would have been qualified to do at the beginning. But now I can put it all together and add value, but not have to be doing what I was doing when I was 27, which I liked when I was 27.
That's so exciting. My daughter just completed law school and cleared the bars in New York. What advice would you give to young lawyers on how they can have a dream career like you've had, being the running back, being the quarterback, being there to support other lawyers and law teams? How would you go about doing that in this day and age with all the complexities?
It's a wonderful profession to get into. You have to see around corners. You have to work hard and think both. You have to say, what could go wrong or what could go right, or how do we structure this? Whether it's a corporate law or whether it's a litigation, your skill set is your ability to think like a lawyer, is what they tell you in law school. Think like a lawyer. And there is a thinking like a lawyer mentality, which is understanding the situation, identifying what the issues and problems are. The real lawyers are able to come up with solutions. For people coming out, I think you have to immerse yourself in the profession, which I always thought was wonderful. I miss the environment and the culture, 100%. My wife was a legal recruiter. We worked together. So we were immersed in Kirkland culture. She worked there for more than 14 years. So we were 34 plus years combined at that firm. When we were there, we loved the culture. We were immersed in it. If you want to go into private law, there's also government law, which I honestly don't know much anything about. But in private law practice, I think you want to immerse yourself and go to the best possible firm that you can find that has the best fit for you culturally, where you feel like you found a place that you feel like you love the people, because you're going to spend a lot of time. At least when I did it, we would eat dinner together and go back to work, and we'd socialize together. It was really an all-in profession. I think that's the best way to really develop, is to immerse yourself as a new lawyer and to learn from the best. The more proactive you are, like the more you're going to get out of it. The more senior lawyers that have more experience, they really like it. When people come to them and ask questions, you're going to get out of it what you put into it. So the more you go, the more you push, the more you try to learn, the more you try to take on responsibility. When someone says it's Friday at 5 and here's this terrible project, I was like, yeah, I'll do it. The person that raises their hand and takes that 5 o'clock phone call and does that really hard project, okay, then they're going to give you more and more and more. So my advice is, if you're going to do it right. Go 100%, 110%, whatever, for as long as you can, to learn as much as you can. If at a certain point you're like, well, that may be too much. Then you can pivot and say, okay, now I have that foundation. What do I do with it? I enjoyed it. I think it's a great profession. It requires a certain level of commitment.
Very true. This is why I talk to people, even if they're running at full speed. I stop them and talk to them. You never know who you're going to meet and what you're going to learn from them. To everybody listening, there's so much we can learn. The world is changing really fast. Machine learning, generative AI, the legal framework around it, the marketing techniques around it, even our health and happiness is going to change as we have newer products on the market, newer ways of dealing with things. So please come forward, tell us your story. I'm eager to learn more, because that's the only way we can co-create a future that we can live with, that we can be happy about. And Eric, all the best to you. You finished that marathon that you set out to do. Which marathon are you planning to run?
I like the Oakland Marathon. I've done the Big Sur. That's a lot of hills. It's a great way to think. I love running. And I was happy to stop and take a picture, by the way, because I get to meet great people too. You never know where it's going to lead.